Because of the time that we have to deal with this nominee, I'm only going to speak about the Sixth Circuit nominee at this point. There are two issues concerning this nomination of the Sixth Circuit, Andre Mathis. One concerns an issue that came up during vetting, which showed that Mr. Mathis' driver's license had been suspended 3 times for a total of approximately 10 months for failing to appear in court to address speeding tickets. This raised concerns from senators about the failure to appear in court and about extended periods of driving without a license. Mr. Mathis has agreed to discuss this issue publicly, and that made possible his appearance today. And I thank him for agreeing to do that, to be very transparent. The second issue is what the chairman has already discussed, the blue slip process. And that means that he does not have the support, as Senator Durbin said, of either of the home state senators. The blue slip courtesy serves as an important, specific purpose to ensure that the White House consults with home state senators before nominating an individual to the bench. This is because the White House decided not to consult with the Tennessee senators in good faith. When I was chairman, I ensured that this consultation occurred, and I assured that the White House counsel properly documented that consultation. With the last administration, the White House generally solicited candidates from senators, proposed candidates, met with the senators, suggested candidates when they were put forward, and solicited feedback from senators after facilitating the meetings. This process involved ongoing communication back and forth between the senators and the White House. Sometimes that process resulted in senators reaching an agreement with the White House, as they did with Senator Durbin in several incidences. But when senators objected to a nominee simply because they were too conservative, that was not sufficient to stop a nominee. That is not what has happened in this case. Here, the White House failed to consult with the home state senators in good faith, and I think we can document that 2 phone calls is not consultation. The Tennessee senators engaged in good faith efforts to find a consensus nominee. They did not delay in providing a suggested candidate. Instead, they suggested as a candidate Judge Camille McMullen. She has experience arguing before the Sixth Circuit. She has been a judge for more than a dozen years. She was appointed by a Democratic governor. The White House offered no substantive response. The Tennessee senators are right to be upset. They tried to work in good faith with the White House. The approach adopted by this administration ignores the idea of bipartisan cooperation. It is a severe change from past practices to require so little consultation. As has been said before, there cannot be one set of rules for Democrats and another set of rules for Republicans. Thank you, Mr. Chairman.